So we continue to monitor the proceedings of the 3 police officers accused of killing Eldorado Park teenager Nathaniel Julies. Let's cross to that court hearing now.
Accused number 1, applicant number 1, summoned applicant number 3 solely for the fact that he wanted applicant number 3 to go to the scene and tamper with the scene. Because the court has already heard from applicant number 2 that according to her, applicant number 2, it is applicant number 1 who called applicant number 3 to the scene. It is also, Your Worship, evidence that we are putting to you from the bar that there was therefore an intention from the applicant number 3 to work hand in glove with applicant number 1. Your Worship, investigations are not done. Investigations are still ongoing, and we don't know as to what will the investigating officer be looking for. Perhaps you would want to go back to the scene, and should you then grant applicant number 3 bail today, because he has already shown the propensity of defeating the ends of justice. He might go back to the scene, tamper with the scene, by so doing destroy or conceal evidence. So, Your Worship, investigations by the state are not done. My learned friend is saying applicant number 3 does not have any previous conviction, and it is the first time he transgresses the law. Is that an admission that he has transgressed the law? Because he's saying, and I'm quoting, no previous convictions, and it is the first time that he transgressed the law. That means it is an admission that as you are sitting in front of applicant number 3, he has transgressed the law. Which law? The law that is contained in the charge sheet that is before you. My learned friend is also talking about State versus Branco. He talks about bail conditions. Your Worship, we cannot start by going to bail conditions if we have not clarified the first leg, which is exceptional circumstances. The second leg, is it then in the interest of justice that they are released, particularly applicant number 3. At no stage has the State, Your Worship, indicated that there is a closure from the community of Eldorado Park. There's no closures yet, because this matter has not gone on trial. And, Your Worship, it is still the State's stand that we are opposing bail, as per the evidence that is before you. And furthermore, there is also a petition from the very same community that says we do not want all applicants to be granted bail. Your Worship, the defense for applicant number 3 is challenging the schedule. And Your Worship, I am sitting here asking myself as to, there is a certificate that was presented to me that says the proceedings are going to be governed by Schedule 6. Was there any opposition from applicant number 3? Now, section 50, subsection 6, paragraph C, it says, if a certificate has been granted, which it has been granted, then there is nothing that we can do. I therefore, Your Worship, implore you to disregard this particular argument, because it is not relevant in as far as the issues are before you. Lastly, Your Worship, I'm not going to deal with the issue of accessory after the fact. Perhaps you would want to ask the State as to why. We do not want to engage in a trial before the actual trial. The bail law says if there is a prima facie case based on the balance of probability, we are not going to argue doctrines at this particular stage, because doctrines at this particular stage, they are not important. As long as there is a prima facie case based on the balance of probability. Before you are charging the applicant number 3 with those counts. And the trial court is going to, of course, be engaging in the decision as to whether applicant number 3 is guilty or not. We'll then go to applicant number 2. But rather, before Your Worship, I go to number 2, the last issue on applicant number 3. Applicant number 3 went to the scene, misled the community, or members of the community were there, particularly the family members. He said to them, "No, look, I am unable to assist you because I am not on duty." But he goes to Baragwana Hospital, takes the 2 bullets, went to the scene, planted them there. But Your Worship, he failed to do what was morally and lawfully important of him to do. He did not assist the family. Why? Subjectively speaking.
Just a minute, you said, where did he get the bullets from?
According to applicant number 2, applicant number 3 got the bullets from applicant number 1. That is according to applicant number 2. I go then, Your Worship, to applicant number 2. Your Worship, my learned friend for applicant number 2 is taking us through the types of intentions. But for the sake of bail applications, that is not relevant. As to, is it dolus eventualis, indirectus or directus, for now it is irrelevant. Because we will be engaging in the process of the trial court. To make matters worse, my learned friend is also quoting from the 4th edition of Sneeman. But unfortunately, we are now on the 8th edition. And he is also talking about the common purpose. Your Worship, it is a doctrine. We cannot engage ourselves in doctrine unless perhaps this court would say to the state, let us start with the trial today. Then Your Worship, the state will start with the trial today and engaging itself on those doctrines, engaging itself on the types of intentions that we have. My learned friend is also saying that the state has failed to submit statements and or confessions to the court. Your Worship, I don't know under which authority is my learned friend addressing you on when he says we are duty bound to give you the confession, or we are duty bound to give you the statements, or we are duty bound to even read the statements. In terms of Section 60, which governs bail applications, there is nothing, absolutely nothing. And Your Worship, I implore my little friend that if he has an authority, a case law, he must give it to you. If maybe he has a section, he must then give it to you to say, this section is saying the state must give you confession, must give you statements, or must read the statements. Worship is also mentioning State versus Jonas Skitekat. He is mentioning just two authorities. In the same line where he says the state did not read any single state witness statements. Your Worship, State versus Jonas, with due respect, it does not say that state must read statements to the court. No, it does not say so. If Your Worship, there is a particular paragraph, he must then mention it to you. Skitekat, it does also not say so. I Worship, studied these two authorities, they say nothing about that. The other thing, Your Worship, yesterday my late friend was talking about hearsay evidence. Now, he wants us to read all the statements that we have in our possession. But he himself yesterday said hearsay evidence is admissible in bail application. He is correct. That is why we don't need as a state to read statements. How many statements do we have? We have more than 5 statements. That is why the investigating officer in law, in terms of the bail laws, he can come and say, we have the following evidence. There's no need for us to call that particular person who will be given that particular evidence. The reason is simple. Yes, the evidence is admissible in bail applications. Your Worship, I am failing to comprehend as to why my late friend was also inviting you to have a look at the case of Murukhangwe and others. And he told you about that case was here, and that was the decision, and another case was here, that was the decision. Your Worship, the law, in terms of the South African law, you are not bound by those decisions. Those two decisions, you are not bound. Because the hierarchy, in as far as the South African law is concerned, it says that you are not bound. In fact, I implore you to disregard those two decisions because you are not bound by them. Your Worship, he has also mentioned that the state is not honest when it deals with the life of applicants number 2. But Your Worship, it is the very same applicant number 2 who said, I am scared of applicant number 1 because applicant number 1 is threatening to kill me. That is why my late friend yesterday was unable to address you as to if then your client's life is at risk. And you are saying it is applicant number 1 who is threatening your client. What do you want me then to do? Because, Your Worship, it is evidence before you that applicant number 1 has been threatening applicant number 2 to kill him. And, Your Worship, we also do have that evidence that applicant number 1 has been threatening applicant number 2. Your Worship, lastly on applicant number 2, the reason why applicant number 2 is detained where she is detained now is basically because we were advised by the court, not this one of course, to detain applicant number 2 to a place where we deemed fit to detain him. Let me come to applicant number 1. Your Worship, applicant number 1 is talking about the men's rear, but with due respect, at this particular stage, the issue of mens rea is neither here nor there. Why? It's because in front of you, you have a charge sheet that is indicating as to what are our allegations, what are our averments. There is also a statement from the investigating officer that is containing averments and allegations as to was there a mens rea is an issue to be decided at the trial court. The issue of motivation to kill your ship, to murder the deceased, will also an issue that will be canvassed in the trial court. My late friend for applicant number 1 also raised an issue of the right to liberty. The right to liberty, indeed, Your Worship, it is contained in our constitution. But also the right to life is also contained in our constitution. What you have in front of you is evidence that applicant number 1 and 2 took the life of this young boy. Now the question is, what about the right to life? In fact, I want to argue before you, Worship, that in terms of section 36 of the Constitution, which is our limitation clause, it says that all freedoms and rights are limited under this particular section. And State versus Dlamini says to you today, you can limit the liberty of all the accused persons. There will be nothing wrong in law to limit their liberty. Your Worship, indeed, I'm not going to, for the sake of time, I'm not going to quote the sections, whatever. But I want to take this court through some issues so that when the court comes to a decision, it is fair and just. Let's consider section 60, subsection 4A, read with 65A to H. It deals with violence and whatever. In front of you, Your Worship, you have an evidence that the boy was shot as per the instruction to applicant number 2 by applicant number 1. And this young boy, it is evidence not rebutted that he was mentally not well. He had a Down syndrome. How do you then, you should begin to understand police officers who are in the police vehicle? Here is this young boy coming from this vehicle, rather coming either behind this truck, seeing the police van there, because we are told that this boy was very much fond of police or police cars. So he goes there, he is waving to the police. Applicant number 1 takes the microphone, swears at this boy, chasing him away. The boy goes away, the boy comes back. The boy does not make any threats, does not pose any danger. Applicant number 1 instructs applicant number 2 to shoot this young boy. Your Worship, it is clear that they had the hunger to kill. I'm going to refer the court, Your Worship, to State versus C, 1998, volume 2, SACR 72. It's a Cape Division. And Your Worship, I'm going to quote. However, the subsection sends a clear message to judicial officers that a bail risk may more readily be found to exist where the crime is a particularly violent one against another person. Close quote. Now, Your Worship, in front of you, you do have such case. So therefore, in terms of this authority, you cannot grant bail. Your Worship, what then happened is that applicant number 1 is threatening to kill applicant number 2. How will you then release applicant number 1, who is already in front of you through the addresses by the defense attorney for applicant number 2, who says, should I be released? Even if he does not say so, but that is my argument. He says, should I be released? There is a possibility that I might kill applicant number 2 because already I have threatened her. I have indicated to her that if she does not cooperate with me, if she goes out and tell the truth, I will kill her. Will you really, Your Worship, risk that? Will you really today risk releasing applicant number 1? To make matters worse, applicant number 1 is having previous convictions, 3 of them, of which 2 involves violence as an element. So already he has the propensity of not only committing Schedule 1 offense, but committing a Schedule 1 offense where violence is an element. Your Worship, the prevalence of this offense. In front of you, these are the applicants who are members of the South African Police. The allegations are that they have shot this young man dead. And the question is this kind of offense prevalent in our jurisdiction or in the entire country or not? That is the question that you are called upon to answer in terms of the bail. I want to implore you, Your Worship, to invite you. There is a document that was compiled that deals with people who have been killed in the hands of the police. And I prepared that information, and I want your indulgence to put that on record because it's part of our argument. This document, Your Worship, it is titled, "Does the delivery of justice in South Africa have to come dressed in a navy blue bulletproof vest, shotgun, and armed nyalas, or can we imagine justice beyond that?" That is the title of the document. This document, it says alone only in 2019, 3,835 assault cases by the police were reported. It says furthermore that in 2019 alone, 397 deaths were reported caused by police actions. And 214 people died in police custody. Now, Your Worship, also the IPID annual statistics from 2018 and 2019 confirms this, because alone in Gauteng there are plus or minus 150 cases that were reported between the period of 2018 and 2019. It tells you that, Your Worship, there is this type of an offense is very prevalent. I go, Your Worship, then to the next aspect. The emotional ties and whatever. Evidence is before you that all applicants, they don't own immovable property in Gauteng province. They are renting. They are owning immovable property, rather than movable. They don't own immovable, but they own movable property. Now, they've also indicated to you that they are taking care of their independence. But State versus Songwa, 1979, Volume 4, SA 218, bracket D. It was held there that the fact that an applicant support an independent is of little consequence when coming to granting of bail. I then, Your Worship, argue that if before you have that authority, then Your Worship, you cannot grant bail. The strength of the state case. I've heard my learned friends, Your Worship, addressing you on the strength of the state case. State versus Matebula, 2010, Volume 1, SACR 55, bracket Supreme Court of Appeal. In page number 6, paragraph 12, it says the following, and I quote: in order successfully to challenge the merits of such a case in bail proceedings, an applicant needs to go further. He must prove on a balance of probability that he will be acquitted of the charge. Thus, it has been held that until an applicant has set up a prima facie case of the prosecution failing, there is no call on the state to rebut his evidence. In terms of the Supreme Court of Appeal, situated in Bloemfontein, it says there is no need for the state to lay bare its case. It does not say so. Rather, what the Supreme Court is saying is that should an applicant attack the state case, that is what Matebula is saying. It says, should an applicant decide to attack the state case, he or she will be committing a suicide because the burden will be upon him to prove, not the state, but the applicant, to prove that the state case is weak and that come trial, there is an acquittal. The state does not have an obligation to prove the strength of the state case in terms of Matebula should the applicant start to attack the state case. The nature and the gravity or shape of the offense, I'm really not going to burden this court about the gravity of this offense. Section 60, subsection 4C, read with 60, subsection 7A to H. It deals with the witnesses, the court knows, Your Worship, concealment of evidence, and so forth. We want to urge before you that all these applicants, they know the witnesses. Why we say so? Inter alia, applicant number 3 went to the scene, spoke to the family, even to community members there. At least for now, they might be knowing one, or they might be knowing two. Your Worship, it does not need any any intelligence or wisdom from elsewhere.
All right, so those court bail proceedings continue in the case of the 3 police officers who are alleged to have murdered Nathaniel Julies. We're going to leave it there for now. My colleague Arabi